And that is where we begin tonight. At the end of the first week for a 12-member jury impaneled in the first ever criminal trial of a former U.S. president, Donald Trump. Today was the final day for the prosecution's first witness, the former publisher of the National Enquirer, David Pecker. Trump's lawyers continued their cross-examination, focusing on the theme that the catch-and-kill agreement made between Pecker, Trump, and Trump's former lawyer, Michael Cohen, was just standard operating procedure for Pecker and the National Enquirer. They suggested Pecker's actions were based on business considerations, and he would have done them anyway, whether or not he had an agreement with Trump. For instance, Pecker admitted to Trump's lawyer, Emile Beauvais, that the $30,000 payment to buy the rights for the former doorman's false story that Trump fathered an illegitimate child could have led to millions of dollars in sales for the National Enquirer, if true. Beauvais asked, and that is why you decided to pay Mr. Sajudin $30,000, correct? Pecker answered yes. Beauvais, because you could not have him taking his story to another publication if it was true, right? Pecker, that's correct. Beauvais, it would be too great a loss to AMI to lose control of such a story if true, right? Pecker, yes. However, the prosecution had Pecker explain how this agreement was anything but standard. While Pecker admitted to having coordinated thousands of non-disclosure agreements, suppressing stories to help a friend or use as leverage with a celebrity, he was asked by prosecutor Joshua Steinglass, quote, "How many did you coordinate with a presidential candidate for the benefit of a campaign?" Pecker, "It's the only one." Steinglass, "Prior to the arrangement with Trump in August 2015, did you ever preview with a candidate positive stories about that candidate or negative stories about that candidate's opponents?" Pecker, "No." Steinglass, "Prior to that arrangement, did you ever allow a candidate to accept or reject articles?" Pecker, "No." Steinglass, "Prior to the meeting, did AMI ever agree to be eyes and ears?" Pecker, "No." Trump's lawyers also tried to poke holes in the arrangement made with former Playboy model Karen McDougal, claiming it was all above board because in return for payment, she provided her services to the publication. But again, the prosecution shot down that attempt by having Pecker testify once more to the real reason Ms. McDougal was paid $150,000. Steinglass, "Is that true, Mr. Pecker? Was that your purpose in locking up the Karen McDougal story, to influence the election?" Pecker, "Yes." And the fact that Pecker agreed to not publish a story about a Playboy model's year-long alleged affair with a presidential candidate is only further proof that this was not just about doing good business, because Pecker admitted that such a story would have been, quote, National Enquirer gold. The prosecution asked, "At the time you entered into the agreement, you had zero intention of publication, even if it would have helped the bottom line. You killed it because it would have hurt President Trump." To which Pecker answered, "Correct." And before the court wrapped for the week, the jury heard from two other witnesses. First was Trump's longtime assistant and gatekeeper, Rona Graff, for a brief line of questioning authenticating that both Karen McDougal and Stormy Daniels' contact information were in Trump's computer. During cross-examination, Graff did admit to hearing conversations about Daniels potentially being thought of as a contestant for Celebrity Apprentice. The other witness is much more obscure, one of Michael Cohen's former bankers, Gary Farrow, who allegedly helped set up the home equity line of credit through which Cohen paid Daniels. His testimony will continue when court reconvenes on Tuesday. Joining me now is Lisa Rubin, MSNBC legal correspondent, and Tristan Snell, former Assistant Attorney General for New York and author of Taking Down Trump, 12 Rules for Prosecuting Donald Trump by Someone Who Did It Successfully. Lisa, I'm going to go to you first. Hopefully I characterized the day properly now. Tell me what stood out to you in court today.
I think one of the moments that stood out to me most was one that you just covered, because Joshua Steinglass from the Manhattan DA's office was literally right up to the lunch break when he got to that line of questioning about National Enquirer gold. Emil Bovy was trying to establish through his cross-examination that many facets of the arrangement between Trump, Cohen, and Pecker, the thing prosecutors have characterized as a conspiracy, were just standard operating procedure. He used those three words so many times it was like his mantra.
Yeah.
But Steinglass really poked holes in that by showing that the payment to Karen McDougal and the purpose to which it was put was, in fact, anything but standard operating procedure. Because what was standard operating procedure at the National Enquirer? Making lots of money. Right. and he got, Pecker in his direct testimony and in his cross. I thought one of the things that he conveyed was that his bottom line was, in fact, more important to him at times than Donald Trump. It's why that payment for Dino Sajudin, right, he said that he would have published it if true. He relented at one point and said, well, I would have held it until after the election. In other words, Donald Trump really mattered to me. Yeah. But at the end of the day, that story was so juicy, I would have published it. That wasn't true of the Karen McDougal story. And yet he testified that he believed very much this story was true, particularly based on his own private conversations with Trump, who asked him on a variety of occasions, how's Karen?
How's our girl?
How she's doing? Yeah. Now, that sounds like it was a question about her welfare, but really it was a question about, is she keeping quiet? And is she satisfied with the arrangement? Yeah. The other thing that stood out to me today was when Bovy was trying to, again, on his recross, show that Karen McDougal's agreement had value. And he said, wouldn't you agree that you published 65 articles from her, you put her on the cover of magazines? Wasn't she a celebrity in her own right? Didn't her brand have value?
She's a Playboy model, isn't she a celebrity?
Yeah, but the problem is David Pecker knows celebrity better than anyone. Like, if you ask someone to draw a triangle of the hierarchy of celebrity in this country, David Pecker would probably draw it up on a whiteboard faster than you can say a beautiful mind, right? Yeah. And David Pecker was like, well, I guess her brand has value to her, but I don't put her in the category of celebrity. In other words, no, this was not a real utility to me. This was, again, to satisfy her and her dreams of relaunching her career. But as far as I was concerned, she was no celebrity.
She might be the most sort of sad character in this whole thing, because she really thought she was going to become famous and be on the red carpets hosting and being a journalist and being an anchor, and that wasn't going to happen. A real celebrity actually is Arnold Schwarzenegger. Like, he actually is a celebrity who became governor, who also had a catch and kill deal with this same publication. But the prosecution and the defense have sort of tussled back and forth on how that was different. How was it different?
Yeah, I mean, look, it's not the same. It wasn't the same kind of dollar figures. The timing wasn't the same. And critically, Pecker's testimony about them is different. I think that there was a lot of back and forth there. The defense managed to score some points a little bit there. I think that was probably one of the more effective bits of the whole day for them. But at the end of the day, being able to come back on recross and confirm, it was definitely not the same. It was not with the same intent. And intent is everything here. Yeah. It's all about the intent. Why are we starting with Pecker? Because it starts with that 2015 meeting where they had this arrangement. It was all part of a deliberate process to help Trump get to the White House.
Let me read just a little bit of this, and this is when Bovy is now questioning that this is about Pecker's testimony that Cohen had told him Jeff Sessions is the Attorney General. He's in Donald Trump's pocket. Bovy then asked whether that incident is among those that colored his view that Cohen is prone to exaggeration. Pecker said yes, and then during redirect, Pecker is then asked about average payments when they do these catch and kill stories. They say, you testified on cross that Arnold Schwarzenegger announced his candidacy for governor, and that afterwards some 30 or 40 women came forward, and that you told Mr. Bovy that you paid hundreds of thousands of dollars to kill those stories. Pecker, yes. What was the average of those payments? Pecker, the largest was $20,000. The others were up to $2,000. Right. Just the doorman got $30,000. Right. So it's different degrees.
Totally different degrees. And then, you're looking at these giant six-figure payments to McDougal and to Daniels, like that. It's a totally different ballgame.
Yeah, and also he didn't admit to campaign finance violations, although he might have committed state crimes in the Arnold Schwarzenegger case.
And in this case, he admitted he did. Investigation, right? The reason that David Pecker said he was even sensitive to the campaign finance angle of paying McDougal in the first place, which is what caused him to lard it up with services, right? He was sensitive about that because as a function of what he had done for Arnold Schwarzenegger, he had caught the attention of regulators and investigators, and he narrowly escaped. So he knew that that was a problem. He tried to structure the Karen McDougal pay-out agreement in a way that would evade campaign finance problems. The only issue is, as Josh Steinglass very expertly elicited from him, while they did hire outside counsel to review that agreement, they didn't tell that outside counsel about, for example, the August 2015 meeting at which they had that agreement. They didn't represent to him all of the facts that a lawyer would need to render advice. In other words, that advice was meaningless because he was reviewing the agreement in isolation. He took a half-hour glance. Literally, Pecker said, we paid him for a half an hour of his services, and it passed muster. But they didn't give him all the information that a real election law expert would need to basically say, yeah, I don't think this is kosher.
Okay, let's talk about Rona Graff. What is the value of Rona Graff, and what did she provide? So what did she do for the prosecution or for the other side today?
Yeah, so, Rona, just for everybody's background, is very interesting because we haven't talked about her as much in all of these cases, but she is really up there in the inner circle for Trump with Michael Cohen, with Allen Weisselberg, the people that he literally spent had the most communication with.
She's like a personal assistant.
Personal assistant, but was one of the key gatekeepers. We have to remember the Trump organization really only ever had about 14 people working for it. Trump only had about 3-4 people that he was talking to on a regular basis, and Rona was one of them. Handled all of his communications, right? So why was she important? What did she do today? It's that a lot of it was to authenticate a lot of the documents, a lot of the communications that we're going to be seeing later in the trial. And particularly then it was the placement of Stormy Daniels at the property at Trump Tower, and critically the Outlook contact cards.
That she knew.
Of Daniels and McDougal that were sitting there in Trump's Rolodex.
And what's the significance of that? I mean, other than that, it means that Trump knew these women.
Look, the prosecutors don't have to prove that Trump actually had relationships with either Stormy Daniels or Karen McDougal. On the other hand, to the extent that they have circumstantial evidence that there was a real relationship of some sort with both women, that increases the likelihood that jurors will believe he had the motive to cover this up and keep these people quiet.